Edibles, are they legal? Now we know. Stay tuned for the story. I'm John Fabricius. This is Kanna Krew. Stay tuned for the Reefer Report. Today, in a unanimous decision and stunning rebuke of Arizona County Attorneys Bill Montgomery and Sheila Polk, the Arizona Supreme Court has held that Arizona residents who possess a valid medical marijuana card are immunized from criminal prosecution for the possession of cannabis extracts such as hashish, oil, edibles, wax, and other extract products. The highly anticipated decision stems from a criminal conviction of Rodney Jones for the possession of 1.4 grams of hashish. Mr. Jones was a registered medical marijuana patient in the state of Arizona at the time of his arrest. His arrest took place in Yavapai County, Arizona, under the specific policy of County Attorney Sheila Polk, who, along with Maricopa County Prosecutor Bill Montgomery, had determined that an earlier statute in Arizona superseded the voter-initiated and approved 2010 Arizona Medical Marijuana Act, known as the AMMA. The earlier statute defined marijuana and its extracts as two distinct narcotics. Moreover, the county prosecutor stated that due to the AMMA's failure to specifically cite extracts, the voters of Arizona did not intend for the AMMA to cover cannabis extracts. Both county prosecutors encouraged law enforcement to arrest medical marijuana card holders that possessed extracts. Remarkably, however, both county prosecutors refused to conduct raids or arrest business owners in Arizona that sold such products. Both county attorneys reserved prosecution for individual medical marijuana card holders who believed that they were in compliance with the AMMA laws. During the pretrial stages of Mr. Jones' prosecution, his attorney filed a motion to dismiss the charges based upon Mr. Jones being a valid medical marijuana card holder. The trial court denied the motion to dismiss. Mr. Jones was tried, convicted, and sentenced to 2 concurrent 2.5-year terms of prison. Mr. Jones appealed the conviction and sentence to the Arizona Court of Appeals. In a 2-to-1 split decision, the Court of Appeals affirmed the conviction and sentence. Mr. Jones then filed an appeal to the Arizona Supreme Court, a court with discretionary review. The Arizona Supreme Court granted review of the case to determine if cannabis extracts are authorized under the AMMA, relying on a plain language interpretation of the AMMA. The Supreme Court held that the statement in the AMMA, wherein it defines marijuana as all parts of the plant, that the word all means extracts as well as the flower. The unanimous decision vacates Mr. Jones' conviction and sentence in whole. However, Mr. Jones had already served his 2.5-year term of incarceration. Medical cannabis users, dispensaries, and the cannabis industry had long awaited the decision and heralded the Arizona Supreme Court's wisdom in the unanimous decision. One question that was asked and partially answered in Tuesday's decision was whether the 2.5-ounce limit prescribed in the AMMA applied only to the flower or its extracts as well. The Arizona Supreme Court held that the AMMA language regarding the 2.5-ounce limit only applied to the flower product and not to extracts. The court did not state specifically what the legal amount of an extract is, other than to say that the authorized amount of extract could not be derived from more than the authorized 2.5 ounces of flower. This question then remains unresolved. And in our next story, the Transportation and Safety Administration has now made changes to the guidelines as to what passengers may bring on board a flight in the United States. The new guidelines authorize the possession of hemp-based CBD products or other such products that are already authorized by the Food and Drug Administration in carry-ons or checked baggage on a flight. This is a change from the previous guidelines. However, there is some misinformation out there about whether or not this affects medical marijuana users or marijuana users from states that have authorized the recreational use. Nothing in the new guidelines references anything to do with cannabis marijuana, whether it's legal in the state of origin or whether it's a medical marijuana patient. That does appear to still violate federal law and would be prosecuted by TSA agents if someone were to bring that on board a flight. This seems to be only reserved to the CBD product and also seems to be in line with the laws passed by the federal Congress earlier this year in regards to hemp-based CBD and hemp products. I'm John Fabricius with Kanna Krew. This has been the Reefer Report. You can find all these stories and much, much more across all social media platforms and on our website, kannakrew.com. Remember, it's not just cannabis, it's culture.